matters for many years. But last Wednesday, the Lord Justice Clerk, Lord Gill, presented me with the Scottish Civil Courts Review. It is a hard-hitting report, the first system-wide review of modern times. So I begin by thanking Lord Gill, his colleagues and his staff and team for all their work, and I thank Cathy Jimison for her foresight in commissioning the review during her tenure. In his opening paragraphs, Lord Gill pulls no punches. He says, and I quote, "The basic structure of civil jurisdictions in the Scottish courts remains much as it was in the late 19th century. Changes in the social and economic life of Scotland have left us with a structure of civil justice that is seriously failing the nation. Reform is long overdue." These conclusions are now unavoidable. Our civil courts now operate in a rights-based, property-owning, consumer-orientated, insurance-reliant society of the sort that was unrecognisable a century ago. A reliance on ad hoc reforms has delivered a system of civil justice that is unfit for today's purposes. Lord Gill says the practitioners of 100 years ago would have little difficulty picking up the threads of today's courts. Seriously failing the nation is a severe summary. Lord Gill has diagnosed failures in efficiency, economy and expedition. His is a diagnosis of notorious and sometimes scandalous delays that ill serve our people. His proposals for change include stricter management of cases, with sanctions for breaching the rules, a major transfer of jurisdiction to the Sheriff Courts, with cases worth less than £150,000 taken out of the Court of Session, most appeals to be handled in the Sheriff Courts from where they sprung, and the requirement of inner-house permissions, the simplest cases to be dealt with under a new procedure before a district judge, and a host of technical improvements. The report has been broadly welcomed by all of those who believe that the people of Scotland deserve an accessible system of civil justice, one that delivers fairly, economically and promptly. I cannot address all his recommendations today. His report extends to 700 pages, with evidence presented in 11 informative annexes, detailing the disproportionate cost of litigations, excessive delays and volumes of business, as well as lessons to be learned from other jurisdictions. But I can broadly welcome these recommendations and accept their twin thrusts: jurisdictional adjustment and procedural change. Cases must be dealt with at the level which is appropriate to the importance and complexity of the case, and the court should ensure that cases are properly managed with an end to drift and repeated procedural hearings. Reforms in the commercial court and summary criminal cases have shown that this can be done, and it must now be done throughout the system. It is absurd that more than half of the cases coming before the Court of Session cost more to sue than the sum being sued for, an average of 222% more in the lowest value cases. It's increasingly odd that the average time for a case to reach its conclusion continues to grow. Without access to today's technology, the Roe v Wade decision was issued in 3 months, including holidays, and the Nuremberg trials were concluded in 10 months. Our delays are not justified. They delay justice. They contribute to Scottish businesses choosing other jurisdictions for their own litigation. So we should all agree on the needs of driving reform, modernisation, a change of culture and a whole system approach. We will carefully examine the specific proposals in their detail. Some matters could be implemented soon. Others will require careful costing and a different public finance climate. Some solutions are at the disposal of the court. Others are for the government. Others still are shared. But that does not diminish the urgency of our moving forward in this general direction. And I therefore invite the opposition spokespeople to reach an early agreement with me on the recommended changes that can be rapidly progressed, and that we can therefore do so together. By all means.
Robert Brown will be aware that Lord Gill very specifically said that his report was not to be cherry-picked and should be dealt with as a whole. Now, I'm not necessarily saying I agree with that, but I wonder if I have the Cabinet Secretary's view on that particular point.
I think I still accept both Lord Gill's direction and indeed that matter said by Mr Brown, but obviously there are matters that will require primary legislation. There are other matters that can be dealt with much more expeditiously. What I would like to see us do is not wait until matters have been fully canvassed, sorted, gone all round the houses, further procedural delays. If there are matters that each and every one of us can agree upon that will advance civil justice, let us do so. That offer is open. If there are matters that we cannot, we'll not seek to produce it or to proceed. But as I say, where we can make progress, for goodness sake, let's make progress. Where we're required to make deliberations, we're happy to do so, by all means.
Margaret MacDonald.
Thank you, Deputy Presiding Officer. I wonder if I could further press the Minister and say, has he identified some areas that we might start with?
Matters won't be within the jurisdiction of the Government. Some of these matters that don't require primary legislation, for example, will be within the domain of the Rules Council and a other variety of bodies. So all I'm trying to say, Ms MacDonald, is that matters that we can agree on politically, where we can accept that we may have to wait some time for primary legislation. If progress can be made, then we should seek to do it. If that is matters that have an input by the Government or this legislator, we should press on. If it's matters where we can encourage others, whether within the Rules Council or elsewhere, let us do so. You're quite correct, and I agree with Mr Brown, that this is a package and it has to be viewed in that totality. Equally, we don't have to wait until every T has been crossed and every I has been dotted before we deliver change. So if there are matters that can be resolved, let us do so whilst we work towards the general thrust. By all means.
I'm grateful to the Cabinet Secretary for giving way. Is one of the issues that he thinks that we could all get agreement on then the introduction of the Mackenzie Friend process?
Minister.
I'm more than happy to look at that because, as I say, clearly that's an aspect that Lord Gill has commented on. It's an aspect